coming our way right now. It is Dave Zumpano from the Estate Planning Law Center. We got him on the phone line. We catch up with him every month here. And Dave, good morning. How are you?
Good morning, gentlemen. I'm ready to go rolling on a river.
Rolling on the river, I know. Well, if you're on the thruway, they're talking about eliminating the tolls here. That was a part of our conversation yesterday. A lot of folks chiming in on that. But hey, continuing to roll down the path of life here, Dave, and I know there have been many changes, I'm sure, for most of us here. I think a lot of folks are happy now, the fact that they can gather and get with family and have birthdays and events and celebrations and graduations, the whole 9 yards. But planning is still a part of all of that, something that we shouldn't put aside, something we shouldn't forget. I know we've talked about many ways throughout not only the pandemic, but now just for different maybe comfort levels or the availability, time-wise, schedule-wise, for folks to go and start some of their planning with different apps and the availability. I know Guider was one of the things we've highlighted and talked about. But, Dave, what's new in the world of planning here as we start to come out of this pandemic, I believe, right?
Yeah, well, it's one of those things, people listening, and they'll listen and they're always interested, and they're like, yeah. One of the two things I wanted to really talk about today. One is, are we there?
Oh, yeah, we're here.
Oh, you can hear me. Okay, I didn't know if there was static. The two things I thought maybe we would hit on is the first is, who's got your plan done? So do you have it done, or does the government have it done for you?
Right.
And then the second thing I wanted to talk about a little bit was the role of a fiduciary, because it's a funny word. People hear, what's a fiduciary? What does all that mean? So I thought I would hit those two things in our time together this morning.
Let's do it, yeah.
So the first thing, a lot of people, I was with friends last night, two other couples, and talking about it, and one of them was actually saying, I don't think I have my planning done. Now, these are good friends of mine, and they're in their mid to late 50s, and I'm like, you don't have she goes, I said, do you have a power of attorney, a healthcare proxy? They're like, I don't think so, right? And they've heard me talk about it. They know what I do. And it's just a conversation that just doesn't hit a lot of people all the time. But here's the thing that's interesting. If you say to individuals, well, do you want to do your plan or do you want the government to do your plan? Hands down, I think 100 out of 100 would say they want to do their plan.
Of course.
But I think it's important for those to understand if they haven't done their plan, then the government's done it for them.
So Dave, I want to stop you just quick. So I would only assume that in some of a similar situation, many folks would probably answer just like your friends. If you said, "Hey, do you have a plan?" No, I don't have a plan. They know they don't have a plan. Even though they didn't do it, they would still want to do it themselves, right? I mean, and knowing that they have it and that there is some plan out there that the government already picked for them.
Yeah, well, see, it's like people think it's a whole bunch of work, or you got to think a certain way, or oh my gosh, it's complicated. People put it off like it's an event that takes a lot of thinking and stuff. It really isn't. It's really kind of simple. And Guider is an example how simple it is. You can go online and have it done in about 25 minutes. Again, for a basic plan, but it's essential. We call it the Essentials Plan because it's got the three essential documents, the will, healthcare, proxy, power of attorney. But what people don't understand is by not addressing it and doing it, they're doing two things. Number one is they're letting the government dictate who's going to make decisions if they stay alive or not. They're letting the government dictate how their assets are managed in case of their disability, and they're also letting the government decide who gets their assets when they die. And I don't think anyone really wants to do that, but for some reason they kind of pause. And I get it, I guess. But the second thing they're doing is they're really creating a lot of extra legal and emotional trauma for their children and loved ones. Because when something happens to you, it's who's got to take care of it? Your loved ones. Now, in the meantime, if there's a husband and wife, understand the loved one's your spouse, right? So if the husband goes down and the wife goes down, either from disability or incompetency or death, the surviving or the other spouse is that loved one, or the children is that loved one. And they have to go deal with this. And you want to talk about time you spend with a lawyer, it's probably 10 to 20 times the amount of time that it would take if just do a simple plan. So that's really the first thing, really, is understanding not to delay, especially now with the simplicity of Guider, where you can just go on, click on the button, and then walk yourself through and fill it out yourself. Who do you want to be in? Who do you want to make your healthcare decisions? Who do you want to make your legal and financial decisions if you become disabled? Who do you want to manage your estate when you pass? Who do you want to get your assets when you pass? Those 4 questions, right? Mm-hmm. Which really raises my second issue for today is that word fiduciary.
Right. Yeah.
So everybody says, well, who's your fiduciary? What's a fiduciary? If you look up fiduciary in a dictionary, it's someone of trust, someone of high trust. And the key distinction with a fiduciary is there's someone that does something on your behalf, but they have to put your interest ahead of their own.
Right.
So lawyers are natural by law fiduciaries. We have to always put the needs of our clients ahead of our own. Trust officers, bank officers, financial advisors, accountants, all those professions by law have to put the needs of their clients ahead of their own. Mm-hmm. In estate planning, the fiduciary is the individuals you choose to make key decisions for you. So one fiduciary would be the person you appoint as your power of attorney. Again, which always throws me, the word power of attorney, I don't know why the word attorney is in there. It has nothing to do with an attorney, but it means you're giving someone the power and authority to act on your behalf to do financial and legal decisions. For example, if you became incapacitated, they can access your checking account to pay your bills. They can, let's say you became incapacitated by a car accident. They can initiate a lawsuit on your behalf. They could do all your financial and legal matters. They could stand in your shoes, but again, always have to put your best interest first.
So you would trust in with your legal matters and also personal matters.
Exactly. Mm-hmm. Now, there's one other too. There's a fiduciary, which is your healthcare agent, who you trust with your healthcare decisions. Do we keep you alive? Do we not keep you alive? Under what terms and conditions? Again, that's a fiduciary responsibility. And then the other one, the most common one, is the executor, right? So the executor is the person who administers your estate after you die. They carry out the terms of your will. So whatever your will says, people always say, well, what do I do when I die? Well, your will has to go through a process called probate for it to be validated. And so after someone dies, the person they name their executor in the will, who is a fiduciary, has to hire a lawyer and then go to the surrogate's court, present a whole bunch of legal paperwork, and then get appointed as executor. It's not automatic. Once they're appointed as executor, then they have to take the next 6 months to a year to administer the estate. So that's another level of fiduciary. So the fiduciary, we've covered 3. We've covered the healthcare proxy. That's a fiduciary role. The power of attorney is a fiduciary role. The executor is a fiduciary role. And the 4th most common fiduciary role is that of a trustee. So someone might create a trust while they're alive. And if done properly, I always say that because we've reviewed hundreds of trusts over the years, if not more, that while they have a trust, it has never been initiated, meaning it's never been funded, so it really doesn't work. So when somebody creates a trust, they're saying, okay, well, wait a minute. I'll take my assets and put them in this revocable living trust, and then the trust will own it, but I control it because I'm the trustee. And then what happens is when you die, the trust doesn't die so you don't have probate, so it avoids probate. It's a very common probate avoidance tool. But that person who's the trustee, who is you during life, 99% of the time, becomes someone else after your death. And again, so the trustee is another fiduciary. So these are the things really about making sure you get your planning done and really inquire why you haven't, if you haven't. Secondly, if you have done it, but it's been 20 years or more, most people did it, when the kids were born, and now the kids are long out of college. It's time to update that will. It's time to update that healthcare proxy and power of attorney.
The kids
so many things are changing.
The kids have kids. Yeah, go ahead, Rocco.
Dave, as you laid all that out there, and I'm just thinking to myself, nobody's perfect in life. No attorneys are perfect. No plans go as planned. So all I'm thinking is that you've got somebody. I assume I get older and I get a fiduciary responsibility set up in any of these regards, whether a trustee or an executor or a power of attorney or a healthcare proxy, and then I die or something goes wrong, and then this person that I granted the trust or the responsibility to decide on my behalf in my interest suddenly goes out there and I misjudged his competence or his qualifications, and he starts screwing everything up. So I have my kids or family members saying, "Oh my God, Dad, Rocco died, and this guy doesn't know what he's doing." And at what point is there really an ability for somebody to say, "I'm trusting this person to handle this stuff when I'm gone, and I'm gone, or I'm incapacitated, whatever it is." And then I've got family members that care for me, and they have an interest in some regard too, as far as what happens to me or my estates or my assets. And then they're just sitting there watching a train wreck happen. What happens to stop that? I guess what power or what can be done to really protect, to ensure that the person who assigned a fiduciary and they're gone or can no longer be involved in assessing how that person's handling it, what can be done to maybe reverse some sort of misjudgment on who they assign that to?
Great question. I love that question because it's very common for people to choose the people closest to them to be that fiduciary role. Mm-hmm. And many times they're not qualified. For example, you have a child who's been bankrupt 3 times. He's probably not the best person to make your power of attorney to do your legal and financial matters, right?
Right.
But it's my son. It's my oldest son, right? Here's the reality. Two parts of reality. Number one is legally, a fiduciary has a legal obligation to act in the best interest of the principal, which is you, the person who appointed them. Mm-hmm. So after you're dead or while you're alive, it doesn't matter. You always have to do what the individual who appointed them said. And they have to really account to 2 people. A, they have to account to the beneficiaries who are supposed to benefit from that fiduciary responsibility.
Right.
So any one of those beneficiaries, let's say it's 3 kids and 1 kid is the fiduciary, the other 2 kids could hold the one child who's the fiduciary responsible and say, you have to give us an accounting of what you've done with all mom and dad's stuff, right? And that's very typical in a probate proceeding or in a trust administration where before assets are distributed, there's a full accounting that says, hey, look, when mom and dad became incompetent, when mom and dad died, here's all the stuff I came into possession of day one. Since that time, here's all the additional money that's come in. Here's how I've invested it. Here's the interest. Here's all the things I've paid on their behalf. Here's what's left, and here's how it's getting distributed like mom and dad said. All the beneficiaries then have to sign off on that accounting and confirm, okay, this looks like legit. If the children don't do that, then the court can always do it. So if the children go to the one brother or sister or whoever the fiduciary is and says, hey, I want an accounting, and that person doesn't do it, they can then compel a court can compel that fiduciary, but now you're hiring lawyers. Mm-hmm. And the problem is a lot of times is by the time they do it, the damage has already been done.
Right.
So if the one person is misusing the money, now again, they could be legally responsible, but if they don't have any money to begin with, then it's lost. The bigger problem is too sometimes is that a lot of times people don't know if they're the beneficiary, right?
Right.
And so that's the good cop, bad cop is like, well, how do you know you're a beneficiary? If it's a probate administration, it's required that all heirs are notified. Heirs are the spouse and children of the decedent. So they would have to be notified legally and would have to physically sign a form for the court. When you don't have a will, then if you have an estate proceeding, it's similar. But if you have a trust or if you have beneficiary designations, then it doesn't work the same because it would automatically go, beneficiary designation would automatically go to the other person, not on the beneficiary. So if I had an account and I've got 3 kids, but I make my life insurance policy beneficiary only one of them, then that one child will get it and the other 2 or 3 will never know about it. So it's really interesting. It could be kept as private or as public as each individual planning wants it to be. Most people want it to be private, but the best way to secure against that, Rocco, is to make sure that when you have a plan, and this is the big thing, you share it with your family members. You let your kids know, hey, by the way, if anything happens to me, Uncle Bob's going to be taking care of this or that. Or, I'm going to have 2 of the 3 of you do it together, kind of thing. And that's what we do with a lot of families. We say, after we do the plan for them, we say, would you like to do a review with your children? And many opt to do that, and we have a conversation with the children so there's no surprises. Now, again, we don't have to sit there and tell the kids how much money you have and who's getting what to the detail, but we give them general ideas. Look, when Mom and Dad pass, here's what's going to happen. Here's who's going to be in control. Here's the process that's going to happen, and things of that nature. But you're right. It's a double-edged sword. You appoint people you trust. Sometimes they're not trustworthy. The law is there to protect, to make sure they are trustworthy, because, again, as a fiduciary, they have a legal binding obligation to always do in your best interest, which means to distribute your assets in the way you've instructed, or for your benefit if you're disabled. But it's tenuous at times, for sure.
A few more minutes, Mark.
This is an issue that comes up, and I'm just curious if you would weigh in on it a little bit and give us your opinion. But as a power of attorney, you're charged with doing what's best for the person who appoints you. Would you more or less agree with that?
You have to do it.
You have to on behalf of the person who appointed you.
Exactly, right? The principal. Right? You have a fiduciary obligation to always put the interest of the person who appointed you ahead of your own interest, and to do as they instruct in those legal documents to the extent they have instructed.
Now, here's what comes up, and I'm just curious about how you would respond to this. Some people are of the opinion that means that you have to keep the assets, that the person who appointed you, the principal, you have to retain his or her assets in his or her name, and you shouldn't be using them except in a judicious manner. But some people get great pleasure by giving their money to others and helping somebody else out. So the power of attorney says, well, I'm going to give, the principal wanted me to give money to my son to help him through college, wanted to give money to my daughter toward her wedding. And so they do make these transactions, and then people say, well, you're not acting in the best interest of the principal because you're giving money away to others, and it should stay with the principal. Now, what is in the best interest of the principal? Is it to keep as much money as you can for the principal, or is it to give money in a manner that the principal might get pleasure knowing that someone else is enjoying it? That, to me, becomes a dilemma sometimes in determining what is best for the fiduciary.
So I think what you're saying, what would the principal want in this fact pattern, in this situation? What would they want to do? I love the question, and let me tell you why, Mark. It's a key distinction I, as an estate planner, have always used to share the difference between estate planning. For example, a trust, a will, a power of attorney, what they do is they grant authority to someone else to act on your behalf. What they rarely do, and this is the distinction between the level of the development of an estate plan, what they rarely do is give instructions of how to use that authority. So, for example, in a traditional power of attorney, there's a tremendous amount of authority given to the agent, the person who's appointed fiduciary by the principal. But it doesn't tell them what to do. It says you can access my bank accounts for my benefit. You can, do stocks, bonds. You can pay my bills. You can do all these things. But it doesn't say what you should do, and it doesn't say you can pay. Traditionally, there is a provision in a power of attorney that says you can give gifts to family members into an amount not to exceed a statutory amount. But traditionally, in my opinion, if a fiduciary, meaning an agent, starts giving money away to one over another, or to my son versus my sister's son, that's going to be problematic, I think, in the eyes of a judge or in the eyes of anyone that challenges them. But to the extent I think those are carried out equally among what we would call the heirs or the natural interests of the bounty, so the people who would naturally get it. So if there's 3 kids, if you did something to all 3 of them equally, I think that's going to be the safest route.
Let me come back on that. Let me come back on that, Dave, because I'm with you, and I understand it's a dilemma. There's not really an answer to it, but I'm just curious what your thought was. But you say distribute equally. But let's say that a person has 3 nephews. We'll say we won't even make him 3 nephews, and one of those nephews goes to college, never been in trouble, doing all the right things. Another one, to use your example earlier, has gone bankrupt 3 times. Another one is in and out of jail. So the fiduciary, the power of attorney, says, I want to give money to the one who went to college and who is not getting in trouble because that's what I think the principal would have wanted. We're going to help that one because that one deserves it, the others don't. So that happens. So then the other people come in and challenge it and say, well, you're not making an equal distribution. But there was a reason, but it's still not equal. It's not fair. And that's not what you're supposed to do. You shouldn't be giving money to one person and not the others. Right. You should just keep it in the hands of the principal. I know there's no answer to it, but I'm just
there is a little bit of an answer. There is a little bit of an answer. Here's what I would say. Again, I agree with you, Mark, that a judge looking at this without knowing anything else of the principle, what they wanted, they're always going to make it whatever the law would say in default of having instruction, which basically says equal. But the one differentiator is the estate plan itself. It's very common in my estate plans that we get very specific to say what they can and can't do, and we do give specific authority, even suggesting to the point that it does not have to be equal. And the key magic words are at the sole discretion of the fiduciary. Now, again, you got to be very careful with that because you got to trust the person. But sometimes if you make 2 fiduciaries, co-fiduciaries, and you say, or with the consent of 2 out of the 4 fiduciaries, then it can be done. So there are ways to make it less tenuous, but there's always going to be a question unless it's specifically spelled out. And again, the better the estate plan, the more of that is spelled out. For example, when we design an estate plan, we usually are spending about 2 to 3 hours with the client in 2 different meetings to get all those details down and really get some specifics, which we call the instructions, and which are much better than not having them. But again, you can't provide instructions for every possible detail, but they're all valid points.
Well, Dave, a very interesting conversation. Again, it's all about planning, the knowledge, knowing what you want to do and who you want to choose here to make those decisions for you, whether it be while you're still living or after you're no longer with us. So with that being said, I know, as we pointed out throughout the program here this morning and many times, there are many ways for folks to get educated, many ways that the Estate Planning Law Center can help, and online documents, as we mentioned, presented or powered by Guider. It's right there on the page, eplawcenter.com. You can find out more. Dave, what else do we need to know about our planning?
Well, I would just say, really, if it's you, if it's your parents, your siblings, your aunts, your uncles, really have the conversation, make sure people have it done, because if not, those of you who are left behind have to clean it up. It's not hard, especially now with the Guider. You click on the Guider button, you can have your essential documents done in 20 to 25 minutes. And again, you do it for the family and with the family. Mm-hmm. And it avoids a lot of stress to the family. And more importantly, it preserves the family relationships.
Sure. And those workshops, they're continuing. I know you have a few set up here for...
Yeah, we have them pretty much weekly. Mm-hmm. So, again, you could register at eplawcenter.com or call the office at 793-3622. Obviously, 315-793-3622. We're always here to help.
Dave, be good. Hopefully next time we touch base with you, it'll be much warmer, and we'll be out of the 20s here, and that'll be
Sounds
nice.
Good.
Back to
we'll be
life.
Rolling down the river.
Yeah, I like it. Yes, soon enough. Dave Zumpano joining us here from the Estate Planning Law Center. Dave, we'll catch up with you next month.
Thank you, Jen.
You got it. And if you missed something, or you want to know more, again, eplawcenter.com.